welcome to part 2, where we have a showcase and walkthrough of Case Create. Hi, CEO, President of Case Create. How you doing?
Howdy again.
So, are you ready to show us what Case Create has?
I am, and I'm gonna try and go through this slowly but still relatively quickly. I don't want to bore everyone, so feel free to ask questions after each section if you want.
Okay, so take it away.
All right. So for starters, everyone, I'm going to introduce the company is. Well, we're changing the product name to Case Create. There are reasons for it. We won't get into that here. So you will see a lot of Case Crafter logos on here as we complete that transition process. So no apologies for that one. But let's get started. So here is our base sign-in, and I'm leaving this up here just in case any of y'all want to reach out and contact me. It's Aaron@eaclawyer.com. I am still a litigator in Texas. I go all over the state. So one of the things that you are going to see is, whenever you create a case right here, you are going to be, you're going to have the option of putting in a case number, who you're going against, what the status of the case is, what state, what date it's created. We may add some more features in the future. Let's go ahead and click our test case here. Okay. So inside of our test case, you're going to see a bunch of random documents. This is where me and the dev team work out issues, and I just kind of leave those up there. But let's go to one of the first things that you'll see inside of Case Create, and that is our petition section. So our petition section, right now, this one is Texas formatted, so you'll see the Texas formatting on the case style. And this is a general petition format. You'll notice that there's a section here for parties, relationship of parties, operative facts, attorney's fees, conditions precedent, and notice of disclosure. Right? Okay, prayer, so on and so forth. Well, what we've got over here is a section where basically it's click to create. All right? So, you've got, in Texas, we require discovery control levels for every case. So you click it, and then a discovery control level materializes. You don't have to write anything, and it automatically populates it where it's supposed to be. Go down here, jurisdiction and venue. So you've got your jurisdiction clause. Click that, and it will materialize. Close it up. Oops. Venue, let's go ahead and pick ourselves a venue. So now, as you can see here on the right-hand side, we've got both jurisdiction and venue. The real bread and butter of this comes down into our cause of action section, whereas we've got, several hundred, or at least about 100, give or take, causes of action, divided up by, really section and then the defined cause of action. So let's look in here at contract, right? So under contract, you've got things like breach of contract, declaratory judgment, promissory estoppel, quantum meruit. In Texas, we've got Rule 185s, unjust enrichment, various items such as those. For this, you would basically just click it, or click, much like you have done everything else, and it generates the cause of action and the elements. Okay, in this particular section, you aren't able to put in the facts. You're just able to click and create as you need, and then you can just fill in the facts as you go, or you can have your lowest cost, most capable hands fill in those facts. We're going to go ahead and close this up. Then we're going to go down here to prayer, and then all we want here is just actual damages. Okay, so down here you'll see that we are looking for actual damages, and here's a little piece that you can delete. Okay, let me save this because we're going to come back to it. And I am just going to say from P for plaintiff to D for defendant, because you have to have those P and D in order to save it. So we're going to go ahead and save that. And you'll see P to D up here on 1019. Okay, so let's go take a look at answers. Answers, same general setup. It has your general denial already populated. It reminds you to put in specifically denying if you want to do that. It's not set up for federal yet, but we are working on a method for specifically denying or admitting to each paragraph. All right, so you've got your notice of disclosure, prayer, and then when you come over here, you can change the discovery control level if you want. You can either agree or disagree with that and move to change it. We've got a list of affirmative defenses that comes straight out of the rules of civil procedure. And then we've got a list of verified denials, or excuse me, the affirmative defenses come out of the case law, and the verified denials come out of the rules of civil procedure, if I've gotten that right. I'm an attorney, I should know this. But they're the same, they work the same way as everything else does, which is click to create, and it will automatically just generate this text so that you don't have to go through your own templates to find a specific affirmative defense. And all of them are right here. So really you can click all of them if you want, read whichever ones you want to, and then delete the ones that you don't need without ever having to wonder, is there something that I'm missing? And if you know of any more that aren't in here, feel free to send them to us along with the citation to the case that has it, and we'll just go ahead and stick it inside of here. All right, am I going to save this? I'm going to go ahead and save this. This one would be from a defendant to a plaintiff. So we're going to save this. All right, and then we're going to move on to our discovery requests. Okay, so with our discovery request, one of Case Create's goals is to have America's largest discovery database. And in order to do that, right now we have 750 questions that are pre-written already in here. Some of these spaces are blank, some of them are not. We continue to add more on a fairly regular basis. But right now we've got 750. My goal is 5,000 before I really turn my focus to something else. All right, but here you can see that your case style is pre-populated. We've got a section here for a general set of definitions, just general stuff, you know, who you are, the property is, you know, experts, evidence, possession, control, any. And then we've got a caveat down here, all words not defined herein shall have their regular and ordinary meanings as used in the trade, defined by Black's Law Dictionary or as defined by Webster's Dictionary, just in case you want to catch all. I've had people try to fight me on my definitions. It never worked. Not since I put this together. All right, so we've got general instructions, basically respond in 30 days. And then we've got our request. Now, here's where the magic happens. You are requested to produce. So let's go back to our breach of contract here on the left-hand side. Okay, we've got these divided up by cause of action and element. So within breach of contract, you've got your enforceable agreement, and we've got a couple of questions here. I'm just going to select a few. All right, you'll notice that they start to populate. So, and I'll explain why this is super useful here in a second, but they basically just populate as you click. You can click any number, all of them, not any of them, do whatever it is that you want to do with them, subject to the terms of service. Wag of my finger. But the idea is that they're here for you to use. One of our primary purposes in creating it like this was so that you could go to a game or presentation or performance of your child, because we know that attorneys live busy lives, and you can attend these events that people want you to be at, that you should be at if you know you're a responsible parent, but you know that your child isn't up there performing the entire time, so you can bring a tablet, you can tether off your phone, you can come into Case Create, you can open it up, and you can start doing discovery while you're there, just reading and clicking. You don't have to draft. You don't have to have a separate software for drafting. You can click while you're sitting right there on the car ride over. And then by the time you get to a point, you know, back to your computer, back to a laptop at the end of the day, you can just go ahead and copy and paste it out or download it, clean it up, and get it off without actually having to find a specific time or a specifically lengthened time period so that you can really think about what's going on.
Case Create be saving lives and family.
You know what? I'm going to have to incorporate that as one of our many slogans that I haven't fully decided upon yet, but I may give some nod to that one. Saving lives and families, or saving cases and families.
Oh yeah, cases and families, yeah.
But yeah, let's save this one. General here, so P to D on this. We're going to go ahead and save it. And you'll notice that, so you've got petition right here, answers right here, discovery request right here. We've got some responses that we're going to look at next, subpoenas, and then jury instructions. Okay, so responses are one of my favorite tools. All right. So right here on the left, you can add as many.
And this was what you used to send 225 questions. Was this?
There is a different tool that I
Okay.
use to send 237 questions. And when we get
37. Oh, yeah.
yeah, when we get to the document crafter section, it's not in there yet, but I will show you one of them. Okay. So, with regard to responses, though, whenever you're looking at the responses, number one, it gives you the ability to type or copy, paste the question. So this is a requirement in Texas law where you have to actually write the question that you're responding to. A lot of people will ask opposing counsel to send them a copy of the discovery that requests in Word form. Most opposing counsel don't comply, and that's a them problem, not a me problem. But more often than not, you're busy copying and pasting out of a PDF. So you have the ability to copy and paste in here, and then you have the ability to type a response right here, and it will just populate on the right-hand side. But the fun part is when you go into the objections, we have over our responses to admissions, productions, and interrogatories. I believe that we've got 100+ discovery objections and counter objections. So let's go ahead and do an objection here really quick. Let's use exceeds level 3 discovery. Okay. This is an objection that we're responding on the basis that this has exceeded level 3 discovery. So level 3 discovery, there has to be a number set. And if you don't set a number, then it defaults to some of the earlier limits. So here we just have the objection. Now, you'll notice our objection is cited to both Texas law and the rules of civil procedure. So you have that and you can modify it to your heart's content, but it's there for you when you need it. But most importantly, if you're a Texas practitioner, you know that our law and our judges say that you have to have the question, you have to have the objection, you have to have whether or not discovery is being withheld on the basis of that objection, or if you have information, subject to that objection, you are providing something. And then you have to have a response, the legal and factual basis for the objection. You have to have that in order for your objection to be responsive. If you don't have it, your objection is non-responsive, and y'all know this. So we've simply made it easier for you to put in a legal and factual basis for your objection, as well as not forgetting this whole withheld on the basis or subject to the objection. All right? There are some softwares out there, and we are extremely familiar with Esquire Tech and their ability to grab a document and turn it into a set of discovery shells. Whenever I was putting this together, I wanted a much lower cost option. So just so you know, Esquire Tech is out there. Case Crafter is right here. Case Create does not have the bells and whistles that Esquire Tech does, but you are also not paying Esquire Tech prices for it. And we'll continue to add to that. But you do have this ability here for yourself. I'm plugging the software.
Yeah.
The full package is about a third of what Esquire Tech charges, but they can do what they want. All right. So, but you can do that all the way down. And like I said, I'm going to be trying to be a little bit more efficient. So let's move forward to subpoenas. Subpoenas, I have taken them and turned them into a 11-question fill in the blank, right? So you basically just scroll down, filling in the name of, the parties, counsel, firm, the deposition time here, and whatnot. Well, these are actually subpoenas for deposition. There is a subpoena ducis tecum right here, just in case you want documents, as opposed to a deposition. But that's where all of these come from. And then right next to it, you have the form notice for a subpoena. And then you have the subpoena with the click of a button, and it's the same data. So I thought that was a rather nifty little tool. The discovery labeler is another fun thing that we designed. It's designed to work with another software that I use in my practice called CaseFleet, but a lot of y'all have it, and I know that we briefly discussed discovery management in part 1. So we don't Case Create doesn't necessarily do discovery management. We help with some aspects of it. So for example, Case Create here will take a document and then it will, let me see if I can do this, because let's use this one. All right, so I'm going to use this meeting agenda, 8/3/21. Okay, let's say that you're doing a lawsuit and your client sends you a document called meeting agenda 8/3/21. Well, that's great, with the exception of the fact that that document is going to be a piece of evidence. So it needs to be PDF'd and it needs to have a label on it, as in what you are going to be calling it. So what you do is you move it over here. All right, so we have successfully uploaded this file, and it deletes all files after 30 minutes. Okay, so you see it right here, meeting agenda 8/3/21, and it's a docx. I want this to be plaintiff's exhibit, and then we're going to start it at number 1. And because it's not a picture, we won't give it another name. But you know what? Just for sake of argument, let's go ahead and give it another name. Even though, no, yes, fine. I'll do it just because I want to show y'all how this works. All right, you click convert. You give it a minute. And boom. What you now have down here is a PDF of that file, and we've renamed it to Plaintiff's Exhibit 1-Agenda. If you're adding in a bunch of pictures, you can add the names, right? So it'll be like picture, so you'll have Plaintiff's Exhibit 1, and then you can name, or excuse me, Plaintiff's Exhibit 1, and then you can call it picture, and then you can do it all the way down. Or if you want sub-exhibits, you do PLEX 1, and then over here, you can start it, actually, you want to do 1 point, and then over here, you would start it as 1. So that way, whenever your exhibit is named down here, you will have Plaintiff's Exhibit 1.1, and then you can have pictures. So that way you can have a whole bunch of pictures without renumbering your exhibits. Anyways, that's how that works, but it's a PDF converter.
Wow.
Whenever
like
it goes... I'm sorry?
I like this, actually.
It's been super useful so far. Almost all of my cases have information that I stick through there. So what we do with this after we convert it and give it that name is we stick it into a software called CaseFleet. And if y'all want my CaseFleet discount code, feel free to contact me for that. I will give it to you happily. Caveat, I do get a $100 gift card from them if y'all sign up, so I want everybody to sign up. But CaseFleet basically allows you to go through and analyze every single piece of evidence that you have. You can make notes on it. You can say, you know, what it is, where it came from. You can make musings on it. You can add questions that you need to ask your clients to about it. And the most important part is that you can tag it to their reports. And whenever their reports come out, you can divide. I have mine divided up by cause of action, an element that I need to support because I use it to write motions and responses and jury instructions and so on and so forth. But you can also generate a report based on the person that's tagged to it. So now whenever you're going into a deposition, you have the report with the evidence that is tagged to that person. And so you can only print, or you can print out just that person if you want. But the reason Case Create is so useful is because instead of going through your files and finding a file that says meeting agenda 8/3/21, you know, in the midst of all of your other stuff, it will say Plaintiff's Exhibit 1-Agenda. And you can go through your files and Plaintiff's Exhibit 1 should be right there at the top because now we've got a uniform naming convention as opposed to you just having to go through raw files. So CaseFleet and Case Create work really well together primarily because, well, I used them and I built Case Create, so I wanted to make it as easy as possible on me, and hopefully y'all can find the same. But we can also clear the table, which you want to do because, again, we're not here to store your data, so we don't store it. It hard resets after 30 minutes, and I don't keep it. I don't want it. But boom, it's done and gone. All right. Jury instructions. Jury instructions are periodically the bane of my existence. I hate going through them and copying and pasting and all that other stuff. So we put this up in a situation where you can basically click to create, right? So we've got this contracts here. So for our breach of contract case that we were doing on the petition side, okay, we need the basic question, existence of a contract, boom, done. Instructions as to formation, authority, ratification, so on and so forth. You click it, it populates it. Then you come back down here to the next basic question on compliance. Here's an instruction for time of compliance, right? So there's a compliance question, and then here's the actual instruction. So no longer do you have to just copy and paste from those books or write it out manually. You can just click to create. Now, I have to caveat this. The state of Texas is real weird about their jury charges. And so we're currently trying to get a certain set of permissions from the state of Texas to be able to use certain parts of the books that they have published. Right now, jury instructions themselves are fairly public, so we're not having a problem with that, but we do want to not step on the state of Texas's toes, and we actually want some of the bonus information that they have in there. So you will not see a lot of the jury instructions in here unless I have specifically needed them and I plugged them in. So don't fault us for that just yet, but that will be populated depending on our position from each of the states. And Tolu, just for your knowledge and the knowledge of your listeners, a lot of those jury instructions are published by the state Supreme Courts of various states. In Texas, we actually have a different schema where the Supreme Court and the appellate courts have authorized a semi-private entity to publish them, which then takes it into the stream of copyright law, as opposed to it just being purely public information that we can do with whatever we want. But some of the other states are a little bit easier to deal with on that regard. So it will develop. Questions?
Yeah, so if a listener is wondering if they could edit here on the platform or download, I'm sure, they can download, and downloads as a document file, right?
Yeah, it downloads and exports, or it exports, as we like to call it, as a .doc.
Okay.
So you can just stick it into. So you
Sorry?
can stick it into Microsoft Word. I prefer copying and pasting, or I prefer saving and copying and pasting. Like, I've been working on this thing for 3 years, and I still haven't gotten into the habit of exporting files. I just love the copy-paste.
Why?
Because I use the copy-paste because it's faster. And at the beginning of the software, when we were working out bugs, there were things that didn't save. And so we've gotten past that. Thankfully,
but you've gotten used to it.
I've gotten used to copying stuff out and saving it in my files immediately after completing the work on it. And so that one, it's just what I do.
Gotcha.
But yeah, so we've got the jury instructions here, and then here is one of my favorites, is our practice checklists. Okay, so
It's one of my favorites as well.
everyone that has been practicing litigation for any length of time has had to draft something late or in a hurry, and come to find out you forgot something. You told yourself that you were going to make a checklist about it so that you wouldn't forget it, but you forgot to make the checklist, and then even when you made the checklist, you put it somewhere and still didn't go back to it. With Case Crafter or Case Create, you are already here. There is already going to be a checklist, okay? So let's look at some of the things that we're going to do for petitions, or let's look at some of the checklists that we've got in here. So here's one for an original petition, okay? So we've just got a checklist that goes all the way down with everything that you could possibly need for a petition, a general petition, in the state of Texas. Now, of course, these are going to grow. There are different petitions for different petitions for different practice areas, in particular family law. They're special. They require certain items, as well as some personal injury cases where on certain allegations you have to include certain information. So we'll have checklists for those as we continue to grow and evolve, but we do have a considerable number of checklists here right now, and we have a considerable number of checklists right now, and that number will continue to grow. There are also some Easter eggs inside of this. And I'm going to give you one, and you guys can find some of the others. These are items that I had to create because I am supremely lazy. Whenever you have a difficult task, give it to a lazy man, for he will find an easier way to do it. I call them generators. So let's say that you are a construction attorney and you have to generate a notice of intent to lien and an affidavit claiming lien. You go to my little practice checklist generator right here. You open it up. You generate a notice of intent to lien. There's your notice of intent to lien. Copy and paste it into your Microsoft Word document. Do some edits. Boom, you're done with a simple fill in the blank. And no one who's using your template can mess this up because it's hard-coded. So you just fill in the blanks, check it when it comes out, and you're done. But then, here's the affidavit claiming lien. All right? Super fast way to generate things like a notice and affidavit claiming lien. And I've got a couple more in there, but I'm not going to tell everybody because it's so much more fun to explore. But we've got all of that for your usage and enjoyment. And now we come to the AI section, which I know that everybody's been patiently waiting for. So, we're calling it our document crafter. And at the beginning of every time you refresh this screen or go into here, there is a disclaimer with a misspelling in it. Find the misspelling. But by proceeding, user agrees that user is responsible for the final product and submission to client, court, and counsel. Case crafter, soon to be case create, is not responsible for human review of drafts. If you click off of that screen, it throws you out. If you click deny, it throws you out. The only way you can proceed to the use of our AI software is by clicking accept. And that is to protect case crafter. It means that you knew that you had to review that document before you sent it anywhere, and you accepted that. So, ain't nobody suing case crafter today. All right. So, let's go ahead and give a demo of some of these. So caveat, earlier when I logged in, y'all were not supposed to be seeing the cases that I was working on, but again, it does not matter because all of those cases have already been filed. They are all public information. If you really wanted to, there is a system in Texas that you can use to see every name that my case is on. There are several hundred, both past and present. So just so you're all aware, that's what's going on inside of those. Yes, let's go back to our practice checklist so that I can show you all the Easter egg I was talking about. Notice of intent to lien, the generators. So there's your fill in the blank that you guys already saw. And there is the output document. Fairly formatted already. It's just missing the information that you would find in the fill in the blank. And here is the other, the affidavit itself. Again, per statute, just ready for the information that you would fill in by putting in those blank spaces. Super useful if you're trying to get out a multi-$100 lien fairly quickly. All right, so then we go back to the document creator, go click accept. All right, right now we do demand letters, motions, discovery, traditional MSJ, no evidence MSJ, response to traditional MSJ, and response to no evidence motion for MSJ, as well as an appellate brief. I'm only going to give you a demonstration on the demand letters. I think we should be able to do motions. I guess I'm going to give you a demo of everything except for all four of the MSJs. Okay, so let's start with our demand letter here. The demand letter one is going to be changed here in a bit, but right now, it just asks you for requests, law, and facts. Okay, so we have a pre-written request here. So request the defendant reach the conclusion, and this will be in all of our training materials, but you have to start every request out with reach the conclusion. I don't know why, but that is, even when I was programming it, I tried to make sure that that wasn't a thing, but it just, ChatGPT loves it when you ask it to reach a conclusion. So that's what I incorporated in here, and it's just part of the algorithms now. All right, law. So earlier you saw that we used we had a breach of contract case. So let me grab some of that. I had this already kind of pre-written here. So we're going to go ahead and expand this. So here you've got breach of contract, then you have the elements of breach of contract right here. Okay, so you'll notice that that was a thing. And then facts and evidence. I have a series of facts, and if you guys want to stop the video, because I know that Tolu's podcast has a video set up, but if y'all want to stop the video and read the facts, they've been sanitized, so you're not going to see anybody's name here. But here's just a long paragraph of facts. Doesn't really matter what they are. You ask it to draft. You got to give it a couple seconds, and then it comes out with a demand letter. Okay, so this will be changed a little bit, but what it does is it gives you kind of the law that's governing it. It explains the facts, and as you are aware, so-and-so purchased this, that, and the other, and then gives an explanation of what it is that the person did wrong, and then it will give you a demand specifically here. Okay, so now, again, we generated this after listening to the client and creating our notes, which we were already going to do anyway. Then we plugged all of our notes into the software, and we got a demand letter back in a couple seconds. Then we can go ahead and edit it from here. This is not the final form of this demand letter output right now, so don't be surprised if it changes by the time some of y'all see this. All right, next up, we're going to look at a crafted motion. And here is one that I was actually trying to work on earlier. Reach the conclusion that the court should grant a rehearing for plaintiff due to... Actually, no, hold on. Better yet, okay, our law, we're going to make up some law, and then request. So I'm going to show y'all what I'm doing here, and I'll just do it in real time. All right. Sorry, Tolu. Reach the conclusion that the court should grant a motion to compel defendant to provide discovery responses. All right. Our law. We're going to give it some fake law. Now, keep in mind that our software only uses the law that you give it. Okay. It does not create law. So I am going to create some law, and I am going to cite to that fake law, and then it will generate a response based on the fake law that I have cited. It has no capability of determining between what's real and fake. So it will only output what you give it. So, discovery responses are due within 30 days. And we're going to cite this to Texas Rule of Civil Procedure 192.4. All right. So there's our law. Okay, and then a court has the power to order compliance with the rules of discovery. And this is Aaron v. Tolu, 334, Southwest 2nd, Southwest 3rd, 24. Good enough for me. Okay. Boom. Those are a rule of civil procedure and a piece of case law. Now, let's do some facts here. So, January 1st, 2024, plaintiff provided discovery requests to defendant. Discovery requests were due on no later than February 1st, 2024. Defendant did not comply or did not serve responses to discovery on February 1st, 2024. As of October 19th, 2024, defendant still has not served discovery requests. All right, so there are our request facts and law. Boom, we're going to draft it right here. And we're going to see what this gives us. All right, so here we have our deep issue. Under Texas law, discovery responses are due within 30 days, and a court has power to order compliance with the rules of discovery. Plaintiff provided the discovery request on January 1st, making the response due by February 1, and as of October 19th, defendant still hasn't served any responses. Given these facts and the applicable law, should the court compel discovery to comply with the discovery request? To me, that is a great way of doing a deep issue. So I did steal the deep issue thing from Brian Garner. If he's watching this, note that I am trying to reach out to him to get permission to use the words deep issue, but if I can't get that, then I'll just change it in our software to issue presented. But I absolutely love Brian Garner's framework for major premise, minor premise, and logical question. So it is my absolute favorite. He taught one of my classes. He signed one of my books. So I love him as a paragon of the legal profession. All right. So then this also gives you an operative fact section. So it gives you, headings, subheadings, and it tries to make a story out of it. I mean, it couldn't get too much with the facts that we gave it right here. But then it does attempt to create one so you can edit to your heart's content. You scroll down a little bit further, you've got your argument and authorities. Because of the way the software is written and because of the fact that it won't cite in the middle of paragraphs the way that I would like it to, we had it create a rule statement for the rules that you gave it already. So here are your rule statements. If a party receives discovery request, they must respond within 30 days. All right. And then it'll cite this little rule, or the rule of civil procedure that I incorrectly cited right here, but close enough, right? It'll give you a holding. It'll give you a citation so that you can stick that wherever you need to inside of your own motion. Okay, same thing. If a party fails to comply with discovery rules, the court has the authority to order compliance. So then a court has this is a quote from what we gave it right here. It will do its best to quote the information that you give it. It will do its best. It's not perfect, but it will do a pretty decent job. Complex citations are difficult. But it'll give you another attempt at the citation right there. Then it gives you an analysis, right? So you've got your obligations, failure to comply, continued noncompliance, the court's authority to enforce, and then a conclusion. It allows you to take that conclusion and then paste it right down here because that's still what it is. It's still a mistake. But then you've got your certificate of service and certificate of conference, okay? The fonts are a little bit janky on this one, but whenever you copy it out and paste it into Microsoft Word, you can just, grab it and resize it to your heart's content. But it took us a few minutes to put that together, right? So you can do that in a handful of seconds, or plus edit time, or you can go back through and find your own templates and handwrite it from scratch, whatever it is that you want to do. All right, let's go ahead and reset this. We're back on our little info sheet, so click accept. Did I already mention the hard 30-minute reset? I should mention to you all again, there is a hard 30-minute reset to this, so once you click accept, it will start counting 30 minutes from there, no matter how often you move in and out of anything on the screen. So you will want to reset and you will want to copy and paste out, because unlike the rest, we do not give people the ability to save this data. One of the best forms of security outside of you not putting in your client's data is our ability to not have it. If we don't have it, hackers can't want it. We've taken all reasonable security measures, within the software itself. But again, there are some common sense common sense practices that we've put in place. And that includes a full delete of everything that you put into our AI software. All right, but let's do...
You mentioned that you used Document Crafter to craft 237 questions. Do you want to show how you did it?
I'm going to show you the first one, and
Okay.
then know that there is a second one that is being put into the software right now. All right, and I can elucidate you. No, yes, no, no. I will do that after I have the patent on it, because the patent for that one
Oh,
isn't complete yet.
yeah, that's important. Please.
But let's go through here and let's try and get this one done using that same paragraph of information that we had from earlier. Okay, so here we have the same paragraph of facts. All right, and this is just so for our listeners. As you are aware, plaintiff purchased the above referenced vehicle on July 20th, 2022. Unfortunately, it has been almost a year since the purchase and plaintiff has not received title to the vehicle. It is my understanding that there is a lien on the title because you have not paid off the note as required as part of the transaction where plaintiff purchased the vehicle. On or about July 29th, plaintiff paid X number of dollars in full via cashier's check. A copy of the cashier's check is included. Cashier's check was deposited and you received cash for the payment of the vehicle. Numerous attempts to receive a payoff statement and title have been made, but all have either gone unanswered or ignored. All right, so that's a basic set of facts. Now, we're going to grab this breach of contract because we need the law that we're going under. So there we go. Now we're going to see what this generates. So we've got our facts, we've got our law. And what it's supposed to do is it's supposed to go through, and the second version does this a little bit better than the first one. But what it does is it goes through every fact that you put in here, and it's supposed to create a who, what, where, when, how, and why. Okay? So now, what we've done here is we've created a request, 15 requests for production, 15 requests for admission, 15 interrogatories. It gives you a summary just because I want it to kind of make you think about the discovery that you're sending. It doesn't tell you what to do, but it does. Ew, gross. I need to get rid of that. But it will give you a base set of questions. Now let's look at the questions that it's asking for. So all documents related to the purchase of this vehicle. So right now, purchase of this vehicle on July 20th, 22, that's a fact that's specific to the set that we gave it. That's not going to come from some of your other discovery in your other discovery template databases. That's not going to come from somewhere else. That's coming directly from the information that you gave it, which is extremely important. So communications between plaintiff and defendant regarding the payment of the vehicle. That was one of the facts that we gave it. Documents showing amount paid by plaintiff for the vehicle, including the cashier's check and proof of deposit. Again, all of these are relating to our facts. Documents showing the status of the loan, including whether or not it had been paid off, right? I cannot tell you how many times I have gotten discovery where the discovery has been completely screwed up. The discovery has been completely screwed up because they're using discovery from different cases that don't apply to the facts of the case that I'm on. Or they're using something from a different, or they copy and paste from, let's use the other example that I had, the 3 plaintiffs that I represent against the 2 defendants. There are some instances where an attorney will copy and paste the same 75 questions to each defendant, right? And that's how they want to do it. That's fine. I personally believe that that's a waste of time. So what we did was we created a way for you to generate a ridiculously large number of questions specific to the facts and the circumstances that you have that don't repeat, right? So that way you can go through, and some of them won't make sense. The AI is still AI, but within a handful of seconds, using the same fact paragraph that we used for the other stuff, we got 45 discovery questions. We didn't have to change anything. And we got 45 discovery questions specifically tailored to what we were creating that are ready to be edited and go out. It took minutes. Okay?
Case create saving lives, time, and family. And cases.
We're going to have to shop that one, but I still like it somehow. Somehow we're going to incorporate saving families into this. Saving your marriage 1 hour less at the office at a time.
Right, spot on. Yeah.
So this looks relatively decent, and obviously, it does what it can within the limitations of the technology. There's one coming that's slightly better, but this will get you through on a fairly basic case. Like, it's not complex at all. Worst case scenario, it inspires some questions that you can copy out and edit on your own. All right. Now, we're going to reset again, and we are going to go to the traditional motion for summary judgment. Do I have traditional motion for summary judgment facts? So, over here, we're going to take the same request for our practice purposes, and in our training material, I'll have better stuff. But we are going to use the same training material, or use the same material that we've been using. So, reach the conclusion that the defendant breached the contract and is liable for damages. All right. Then we've got the same facts. We're going to go ahead and paste in that fact paragraph. And then we've got the same law, breach of contract, okay? Now, what we're writing is a traditional motion for summary judgment, all right? The standard for this is that there's no genuine issue of material fact, and that plaintiffs should be awarded damages as a matter, plaintiffs should be awarded damages as a matter of law, or defendant should be held liable as a matter of law. That one, okay? So, it took less than a minute for us to use the same set of facts and the same set of law that we've been flying under to go ahead and create this. So we've got major premise, contract existed, minor premise, plaintiff paid as agreed, but the defendant failed to do this, that, and the other. And then the question, given the defendant's failure to perform their contractual obligations, is defendant liable for the breach of contract? Of course, the way we phrased it, according to Brian Garner, should already have the answer. So here, again, it tries to create a story based on the operative facts that you give it. We're not going to go back through those because you've seen them now 4 or 5 times, or 3 or 4 times. But, our standard for motion for summary judgment is pretty much hard-coded because that standard has been enshrined in law for longer than I've been alive. As evidenced by this Texas 1985, I was born in 86, so it's been around for a while. Standard for the no evidence motion for summary judgment, hard-coded. You can delete it if you want, but we just reserve it. So argument and authorities, it tried its best to take every line that we gave it and turn it into an individual rule statement. And it does an okay job. All right. If a contract existed between a plaintiff and the defendant, then there is a foundational basis for a breach of contract claim. It should better say, if there's offer acceptance and agreement, but we didn't give it offer acceptance and agreement. So there you go. All right. So it'll do that for, again, every single piece of law that you give it under what we're calling the rule statement section. You can use these or you can delete them, but you're going to have to copy and paste them into the actual sections that it matters. Now, you go down here to the analysis section. It gives a nice legal framework that you can keep or delete, but basically it explains the law, kind of cites the law to the judge, and then goes down here and attempts to analyze based on each single line of the law that you've given it while applying the facts. So the existence of a contract is undisputed. Parties executed a bill of sale for the purchase of a vehicle. The bill of sale was signed and notarized at the defendant's bank, confirming the formalization of the agreement. Also, the keys for the truck were turned over. You can add one sentence, but now you don't have to draft an entire motion for summary judgment. And it does this, it analyzes these facts all the way down and reaches a conclusion. Now, caveat. I know that there are people who want to do multiple summary judgments on multiple different issues. If you're going to use case create, do them on one issue at a time. You will save yourself a bunch of heartache. The system tries its absolute best, but it's like a really eager first year. It will put down on the page what you give it and not think a whole bunch about what it's actually saying. So if you give it too much information, it will basically fry its lovely little brain trying to figure out what's going on. So if you do it one issue at a time, you will generally have better results. But it generates that in a couple of minutes off of the stuff that you already have. All right. Any questions on this one before we move to our final demonstration?
No questions. Let's see the final demonstration.
All right. I am super stoked about this. You have no idea how much I absolutely love this particular tool, but this is the Case Create Appellate Brief Drafter. Okay.
Yay!
This was designed because every so often a litigator will have a case where we lose something, not because we were wrong, but because our judge was bad. Okay? So I'm not going to call out my particular judge on this one, but there was a catalyst for this generator. I have a case where a judge made a ruling that because I didn't prove up 100% of my damages in response to a no evidence motion for summary judgment, the no evidence motion for summary judgment was granted against me, and all of my causes of action were pretty much wiped out. Okay? And the judge wrote that in his order. The problem is that that is not the proper standard for summary judgment. The judge refused to review his error when we brought it to his attention. And so, fine. This is why we have appellate courts. And as previously mentioned, the standard for summary judgment has been established since long before this guy was on the bench and since before I was alive. But all things happen for a reason. He created a catalyst for the case crafter appellate brief drafter. Thank you, Judge. So let's go ahead and take a look at some of these prompts. Now, this is not that case. That case is separate and in my files and it's ongoing litigation, so I'm not going to use it as an example right now. But the difference between most of the other systems that we just saw and the appellate brief drafter, we have a second set of boxes. So I will tell you what this is supposed to do. So in our appellant's position, you give it the appellant's position, the person who's moving for the appeal. Appellant's position is that the court committed reversible error by abusing its discretion and making a ruling on the merits of a case in dismissing the case with prejudice despite claiming the court did not have jurisdiction. You don't really need to know that, but you don't really need to know all those terms, but that's the appellant's position. The appellee's position. By the time you get to an appeals court, you already know what your opposing party's position is. In the case that I just gave to you, it is that my opponent's position is no, the court made the right decision in doing this because you didn't prove this up. Okay, great. I know what your position is, so I know how to put it in here already. But you just need to put in an appellee's position for the other side of the case. All right. Then, like everything else, you put in a request. In this case, we're requesting that we're asking the software to reach the conclusion that the trial court abused its discretion by dismissing the case with prejudice on a finding of no jurisdiction, because the only remedy the court has available when it finds it has no jurisdiction is to dismiss the case without prejudice. Okay? So that's our request. Now our law, there's only one law that applies to this, or one law that I'm citing to apply to this, which is one particular case, and it's right here. Okay? So here is the citation from the case, and then here is the holding from the case, and then here is the citation. All right? So we've got our one little quote there with a nice little citation, and then we're going to give it a set of facts. Here come our facts. Boom. All right. Lovely little paragraph of facts. If y'all want to, stop the video and read it, you can, but it's really basic. So we're going to click draft.
Are you ready for the magic?
Are we ready for the magic? I am definitely ready for the magic. All right. So here we have an appeal brief, okay? Now, you've got your case style up here, which we don't put in because you have that. You have the title of your thing right here. You have your index of authorities right here, which we can't create because we're not going to go through and create an index of authorities. Microsoft Word can do that better than we ever could, so we're not going to step on Microsoft's toes. Statement of a case is the procedural posture or what's happened throughout the case. We're not going to program that or design for that because if you pull open a copy of the court's record, you can just go ahead and type it out. On January 1st, this case was filed. On February 2nd, this happened. On March 3rd, this happened. On April something, this happened. So on and so forth. Whether it had gone up to the appeals court and come down, or went around and come back here, and so on and so forth. Like, you can do a lot with that, but we're not going to do that because, number one, you'd have to pull that actual record. Number two, our system would have to go in and find out exactly what was going on, which is not something that I'm willing to do right now. Maybe later, maybe at some point in time in the future, but right now it's more efficient for the attorney to be able to do that than for us to try and figure out what's important and what's not important regarding what's happened so far. So, issues presented. Once more, we use Brian Garner's deep issue structure, and we create the major premise, the minor premise, and the logical question. This time it just doesn't have those labels on it. So then you go down here to the statement of facts. It describes the statement of facts with no argument, or at least that's the goal, states all of the facts of the case as you've given them in a story mode without argument. So it just tells the court what's going on without all the argument. Here is a summary of the argument, which the Texas Rule of Appellate Procedure have also requested or required in an appellant's brief. What the judges do with it, I don't know. I'm imagining that that's how they use to scan it and make an assignment to their clerks. And then, of course, we do our argument itself, where it once more attempts to go all the way down and analyze everything from the lack of jurisdiction requiring dismissal without prejudice, which we saw in the case that we cited, to the analysis of the trial court's ruling. You've got the trial court's ruling here, error in dismissal, and then what conclusion should it reach? Then, this one's funny. This one is more fact determinative if you give it a lot more facts to play with, but it actually creates the counter argument from your appellees or from your opposing counsel side, and it explains why their case is wrong or why they are wrong. Okay, so if I were to say something in the one case I was talking about with the judge that made a mistake regarding the ruling on summary judgment, if I had put that in the appellee's brief side or the appellee's position side and then given all the facts to support it, the counter argument would actually analyze those facts and say why they are wrong in light of the facts that I have determined were correct. Again, the system tries. It may not get it all the way right, but at the same point in time, you can just delete this if you want. I find it super amusing. So then you've got your prayer and appendix, but you can just take it, copy it and paste it out, and there you go. And it all came from these appellant's position, appellee's position, request, law, and facts right there. So I think that it's super useful. I think that is going to save a lot of practitioners a lot of money here in the future. And that's the conclusion of my demo. Thank you.
So, how about lawyers, non-lawyers or prospective lawyers? Yes, that's the right word.
So law students in training?
Yes, exactly.
Was your question kind of how it's
Actually, I didn't complete my question. My bad. So how could this benefit law students? Yeah.
So with law students, I wouldn't call it so much of a benefit as an impact. Although I guess there is a benefit now that I think about it. So let me start where all good things begin, at law school. When we go to law school, we are in our first year. We are taught. It's called legal writing. You're taught in legal writing how to write like a lawyer. Generally you spend a lot of times on briefs. You may spend some time on some light litigation drafting, but it's not really litigation drafting focused. Okay. You may write, I know for a fact that you write a number of briefs. You also may write a contract or some small aspects of a contract. You may also write some small pleadings. Okay. Depending on where you're going and what you're doing. But the general idea is that you will get a small overview of how to write like a lawyer, but more importantly, you will get much more experience in how to think and practice organizing thoughts the way a lawyer would, the way the rest of your professors want to see their exams answered, right? That's where you get conclusion, rule, explanation, analysis, conclusion, or issue, rule, analysis, conclusion. We're taught those frameworks in Legal Writing 1. Well, AI is not proper for a Legal Writing 1 class. You're basically teaching someone who doesn't know how to write, how to use a computer to write these things. That's not a good idea. Just because you can't know how to cheat at poker if you don't know how to play poker.
Right.
Like, you just can't, otherwise you're going to be out there screaming, go fish, not knowing what you're doing. When I went to school, we were required to take an advanced legal writing class. Some of those are, I think the one that I took was litigation drafting, right? So in litigation drafting, you're not taught general pleadings, you're not taught general drafting. We don't do contracts, we don't do wills, estates, or, any of that. We're taught how to write a petition, we're taught how to write discovery, we're taught how to write a motion, how to write an order, just general, those more specific items, okay, for obviously litigation. All right, then we've got another class called contract drafting, but you can take whichever one you want. I was not interested in contract drafting at all. So what I believe is that there should be another class that sits on top of contract drafting and litigation drafting if you choose to go that route, because there are plenty of routes that lawyers can choose to go that don't involve drafting contracts or pleadings. And that one needs to be AI for drafting, or drafting with AI, or AI in the law. Kind of like your podcast. All right. So the reason why I believe that schools are going to have to start paying attention to case create, spell book, Esquire tech, things like that, is because you just saw what case create can do. Imagine, if you will, that, like we discussed in part 1, that you've got me, an attorney, who's making $1,500 off of every petition. The clients know it, the clients have agreed to it. That's the bill. You don't like it, go somewhere else, but that's the bill. Okay. I hand it to an associate and I tell the associate, here's my request, here's my facts, here's my law, here's my control level, venue, jurisdiction, and here are the causes of action that I want. I tell them, I need you to go out here and I need you to draft a petition. I need you to draft a motion for summary judgment. And just in case the summary judgment goes sideways, I need you to go ahead and draft an appeal brief. Just because I want to make sure that the opposing party knows that I'm prepared to appeal this case already. I also want you to draft jury instructions for it, and I want you to draft discovery in relation to that same issue. All right, but because I know that we're sending discovery, I want you to draft a motion to compel discovery when they inevitably don't come back with the proper responses, right? The lowest cost, most capable hands would be someone who has been trained in the use of AI, and they would be able to go into that office and get that most basic information. They would know which systems are available to them, be that case create or someone else, and they would be able to hit the ground running in a way that would make that attorney thousands of dollars on day one with so few screw-ups. It was only a pipe dream 10 years ago, right? 10 years ago, you would have had to have someone like sit there, and you still have to watch that associate, and you still have to make sure that what's coming out and edited is proper, but you're no longer hand-holding them all the way through. They know how to draft. They know how to read and write like a lawyer, starting in Legal Writing 1. They knew how to draft for a litigation firm. That comes from litigation drafting or Legal Writing 2. And then they had the added benefit to wherever they were going in the form of being able to use AI competently through this Legal Writing 3 class, which would be AI in litigation or AI in transactions. And so now they can go out, they can make more money, they can command a higher price tag, they can immediately add value to a firm, and you don't have to be a law review student in order to do it. So I wasn't law review. Law review didn't like me, or I was stupid, so I was lazy. That's it.
But then, see, you've created something amazing, so the laziness paid off.
I mean, I'm definitely appreciative of some of the things that I have gone through now as opposed to when I was going through them. So not being admitted to law review is very disappointing. However, being the creator of this software, which I believe, no one else has to agree with it, but that I believe is one of the tippy top most cutting edges of legal software, like this AI revolution is going to be the equivalent of the internet when all cases started getting put on the internet.
Right.
Like it's going to fundamentally change the way the practice of law is handled, and Case Create and what we've done here, I believe, is on one of the leading edges of that. So I'm pretty stoked about it. I don't need law review anymore.
No, they need you. So how do viewers and listeners get Case Create? What's the website? What other info and all would you like them to know?
So right now, it is going to be found. We are currently in the process of migrating it, although we're going to probably keep one of those domains. Right now, you can find us on casecrafter.net, which is going to be the old name. But very soon that will be redirecting to case-create.com. Okay, so case-create.com should get you to where you need to be, or casecrafter.net. If you want me, as a litigator in the state of Texas, who is able to utilize this stuff to devastating consequences for the opposing party, you can reach me at aaron@eaclawyer.com or 214-799-0776.
Yeah, don't sleep on it, guys. He's a badass lawyer.
Almost forgot.
What's that? Okay.
Right now, casecrafter.net and casecrafter or Case Create, in our terms of service, it states very clearly that you are using this because you have been trained somewhat in the legal profession. Okay? So, while individuals may access the software if they're willing to pay the $150 a month that we're asking for it, pro ses need to be aware that when they click accept on that terms of service, they are saying that they've been legally trained. And one of the things that you'll notice in here is that there is no explanation for anything, right? If you are a litigator, you are expected to know what a petition is. You are expected to know what an answer is. You are expected to know what specific and verified denials are, venue, jurisdiction. You are expected to know all of that because we do not explain any of it, which is why it's so important to have been legally trained somehow before you get into this. Now, if people think that they're legally trained, we're not going to stop them. Go ahead, hop in, knock yourself out. But if something screws up, and you're 6 months in and you've paid us $900 and nothing that you filed is getting through to the courts, you're not suing me. You're not suing me because we're going to go into every aspect of your background. And I'm saying this as a warning. You can do whatever you want. But just understand, this software doesn't explain anything. If you don't know what the requirements are for an appellate brief, you can write one, but is it going to be correct? Is it any more or less likely to succeed because it came out of a computer than otherwise? No, it's not. You need your facts straight. You need your law straight. You need your request straight. You need to know what your appellant's position is. You need to know what the appellee's position is. When you understand those, then you will be able to draft competent documents as a pro se. Other than that, you will need some formal legal training. Sorry.
There you have it, guys. He said it. The boss said it. Techpreneur. Do you like that word, the term techpreneur?
I don't even like the term entrepreneur, honestly.
So what do you prefer? CEO?
Business owner.
Business owner.
This is a business. We are open for business. We have people that are paying us for access to the software. So I get... It's like just within the startup community itself, there's that, I'm an entrepreneur. It's like, there's a connotation that it's someone who is trying something out or is in a field that, isn't fully fleshed out or has a solution that they aren't sure of whether or not it's worked. That's not where we are. We are a small business. We don't have more than a few customers right now, but we are up. We are revenuing. It is functional. I have used it to devastating impact in several of my cases, and I know that people that I've sold it to have used it in some of their cases. So we're a small business. Entrepreneur is
Awesome.
fine. Techpreneur is fine. It's a little bit of a joke, but what do you do? I know that here we are late in section 2, but you tell the viewers what you do. I know that that was kind of a thing in episode 1, but you don't do that often. What's your relationship to AI and the law?
Yeah, so I wouldn't say similar to you, but I think you had a technical background before you went into law, right? Okay, so I had a legal background. I studied law in Nigeria, came to the US to do my master's in law, and then eventually, in 2022 January, I decided to have some pivot into tech. And for some reason, AI just stood out to me. I didn't know what it was, but I just knew I'd heard the term somewhere from a friend. I'm like, okay, this sounds interesting. Let me see what it's about. And then there you have it. I started learning, and honestly, I really love AI. And not just its applicability to law, but just AI itself, the technical parts, the conceptualized parts, and everything. So, I also want to be a techpreneur or a business owner or a corporate owner. But yeah, so actually, I don't know if I should say this, but Elon Musk is more of my motivation because I don't know, we share a lot in common.
I mean,
And
you can say it. The guy's done some remarkable things.
yeah,
Like his politics, I'm not necessarily one to be concerned with, and I think that he made a mistake by buying Twitter. But the things that he's done between Tesla and SpaceX are nothing short of revolutionary. Like, the man deserves his flowers.
yeah, he does. I respect him a lot, and hopefully someday I'll meet him. Yeah. So yeah,
Never
that's
meet your heroes. Never meet your heroes.
why. Okay. All right.
Because, like most people, he's batshit insane.
Oh, in a good or bad way? Okay, I don't
It
think you
doesn't
should say
matter.
this. Okay.
It doesn't matter. Do you see how many rockets he's exploded? It doesn't matter if it's in a good way or a bad way. Okay? It's his money. His name's going to go down in the, the history books of technology for the rest of human existence.
Right.
Okay?
Elon
So,
Musk, in case you happen to like watch this, keep doing what you're doing. You're inspiring a lot of us. Thank you.
your politics, though, bro. Just ixnay on the politics.
I don't want to get into trouble.
We're not going to get
Okay.
into that one. But all right.
All right. Okay. So, yeah, it's been over an hour, and honestly, it doesn't even feel like it. So, thank you everybody for watching, listening. Please make sure even if you are still skeptical, just send it to someone else. People need case create, and I'm not sure you should be skeptical after this because you should trust it. Yeah.
I mean, we've proved up what it can do. It drafts
Exactly.
things so much faster than literally everything else on the planet. Like,
And it saves family.
it saves marriages by one less hour at the office at a time.
Exactly. Okay, so that's it, everyone. Thank you so much. And yeah, take care. Bye.